Well, right now on Fox 40 and Friends, we have a local attorney, Mark Chinn, who practices family law, and today we'll be talking about equitable division of property. I am so glad I got that phrase out without stumbling over it. Our viewers out there may be asking, what does that mean?
Equitable division of property, it's hard for me to say too. All property acquired during the marriage is determined to be what we call marital property, unless it's been received by someone by gift or inheritance and has been kept separate. In 1994, our Mississippi Supreme Court declared that marital property should be presumed to be divided equally. In other words, the contributions of each party, whether they're working or not, should be presumed to be equal in the division of the marital property.
And to my understanding, this was a really good thing, especially for women who weren't necessarily, especially back in that day, the wage earners.
If you talk about the traditional notion that the woman was staying home taking care of the children, which is of course changed greatly, but if you take that traditional notion, in pre-1994 times, the woman oftentimes did not have property in her name, and so she had to fight in divorce proceedings to get a fair share of the property. As divorce lawyers, we often told our female clients, we're going to fight to maybe get you 10 to 20% of the property, which was usually in the man's name. But since 1994, we can assure our female clients, or shall we say the non-wage earning client, that even though you didn't earn the money, even though you didn't acquire the property, even though it's not in your name, you still have a fair shot at it.
And interestingly enough, there was a female Supreme Court justice at the time this was passed back in 1994, correct?
That's correct. Justice Lenore Prather, who is a great lady and a great jurist, was Chief Justice of the Supreme Court in 1994 when they passed those epic decisions that gave women equal rights to property, despite how it might have been titled.
And let's talk about how that decision affects us today. Let's talk about titles. You might think just because you have the title to something, it's all yours, but that's not necessarily true.
My clients, when they come to see me, they're often worried that property is titled in the other person's name, and they think that that means that they lose their rights to the property. It doesn't mean that at all. Another thing that happens often is that people think that because they've worked in a job and acquired pension rights during a job, that that's their property and not subject to division as marital property. That also is not true. It simply does not matter whose name the property is in, who has the title, or who earned it. If it was acquired or accumulated during the marriage, it's determined to be marital property and subject to division.
Mark, what about pensions? I earned this money, I've saved it up.
I'm sorry, it's considered if that property, if that pension was earned during the marriage, those efforts are considered to be marital efforts and subject to division according to the rules of equitable distribution, which say that the efforts of both parties, no matter what they might have been doing in the marriage, are presumed to be equal.
What about prenups? To my understanding, those aren't necessarily ironclad.
Well, they are if I write them. But prenuptial agreements are valid contracts, and they can be used to set aside these rules of equitable distribution. And the courts do recognize them, if effectively drafted, to set aside these rules of equitable distribution and to have the property divided the way the parties want.
I know handling a divorce is painful for everyone involved, but it's a necessary evil, I should say. But I looked on your webpage and it said that you like to help people going through divorce to help keep families standing.
Yes, our motto is we like to handle family matters in a way that leaves a family left standing even though there's not a marriage. There is a process for resolving marital disputes that does not require the adversary process to kick in. The primary method we use is something called mediation, where instead of taking the matter into court, we take the matter before a trained mediator and work together to try and resolve disputes, even custody matters, without going to court and without becoming adversary. It's very possible, and as a matter of fact, when we use that method, it works 85 to 90% of the time.
Well, knowledge is power, and it seems like it's good to have somebody who knows the law or who can fight for you if you are in that position.
Of course. And even though we can handle matters through mediation, it's always important to know that your lawyer is there to do the things necessary in court if he has to.
I would think it helps to have a good lawyer in one of those situations. All right. Well, thank you so much, Mark Chinn. Well, coming up, the future is turning to flying cars. Stay with us.